The Center for Educational Media and the College of Education at Middle Tennessee State University are proud to offer professional development to K-12 educators in Tennessee through our online video library. These videos are aligned with standards set by the Tennessee Department of Education. For more professional development videos, check out our website at cem.mtsu.edu. Welcome back to the SPED Collaborative for Administrators at MTSU's College of Education. We're so glad you're here today. We've had a great session so far today, and we have great sessions this afternoon. I'm happy to welcome the Tennessee Department of Education here today, represented by Ms. Susan Ussery, who is Senior Director of Special Ed Programs in Tennessee Department of Ed, together with Mr. Tate Ball, Associate Counsel for Special Education, Tennessee Department of Education. This is your opportunity to ask questions about policy implementation, and legal issues. So you have the experts standing in front of you, and I welcome you both here today. Thank you for being here, and I'll give you the floor.
Thank you. Thank you, Laura. Appreciate it.
Step in.
Hi, everybody. My name is Tate Ball. I'm our Associate Counsel for Special Education at the department. I've been with the department for about a year now, and here today, my partner in crime, Susan.
Hi, Susan Ussery, Senior Director of Special Education Programs. I've been at the department since, I think, early 2018. Prior to that, I was a speech language pathologist in K-12 school. Worked a short stint also in a private school as an SLP as well. So I'll wear a little bit of my practitioner hat today, but all the legal questions go to this guy.
Yeah. All right, let's see if we can get the first slide pulled up. So we're going to be talking to you today about the role of the LEA representative, and then a little bit about compensatory education and least restrictive environment, kind of hitting three different categories, but hopefully can blend them in as best as possible. So our agenda is going to be, first off, going with the role of that local education agency representative, the LEA rep, then some tips for how to lead meetings, IEP meetings, then implementation of those IEP plans, then compensatory education, and finally closing with least restrictive environment. So first off, the role of the LEA rep. These are going to be the mandatory school-based team members you're going to have. Essentially, you're going to have not less than one regular education teacher, not less than one special education teacher, or if appropriate, at least one special education provider for the child, a qualified LEA rep, an individual that can interpret the results. It doesn't necessarily have to be an assessment specialist every time, but the teacher can interpret those results. Basically, if you don't have all of these people there could be a procedural violation, and that could result in a finding from our department or otherwise. But the requirements to be an LEA rep: qualified to provide or supervise the provision of specifically designed instruction needed to meet the unique needs of a child with disabilities. Second, knowledgeable of the general education curriculum. And third, and perhaps most important, knowledgeable about the availability of the resources of the LEA rep. US DOE guidance has come out and said that if you don't have someone there that is knowledgeable about what they can commit to as far as resources for an LEA rep, you could end up overcommitting and then not being able to provide those services, which could lead to a deprivation of FAPE. So you have to have somebody qualified for all of those things. A couple of cases that came out that where the person was not qualified. First, this Pitchford case, which came out of Oregon. Basically, the representative was not qualified to lead the meeting. Was not aware of the educational curriculum, special education, and therefore the court found that was a denial of FAPE. And in this other case, out of California, the representative lacked the authority to commit resources, and so then the parental participation rights were violated because the student could not get the services that were actually included in their IEP. So let's keep going. The LEA rep as the process leader, I think Susan's going to talk a little bit about this.
Yeah, and I know sometimes it's challenging. You're expected to be in 10 places at once, so finding an LEA rep to lead a meeting can be a challenge, especially if it is somebody who is knowledgeable enough in the information related to special education. So sometimes it is a pitch hitter, but that's when it is critical that that person understand what their role is. And as far as the LEA representative, and a lot of this we hope is going to be common sense to many of you, but just understanding if you're designating administrators who don't have special education backgrounds, just understanding what their role is. And as Tate said, that commitment and allocation of resources. A lot of decisions are made in those meetings, and it may be expensive to the district. So it would behoove the district to really understand who is leading that role.
And the team leader should also make sure that every member of the team has a full awareness of what role they're playing in that IEP team meeting. So make sure the roles are defined going in so that there's less confrontation about stuff during the meeting in front of parents.
But that lead LEA person, we look at them as being kind of the process person. Often it is the administrator, and they have an expertise in leading meetings, facilitating, and then they can leave the work of the actual practitioners to do the content piece and be the experts that they are to talk about the evaluation results, to talk about the services and the proposals. So it's almost like a neutral party, if you will, but also to support those educators. I will say as a practitioner, it was always great if your principal kind of knew what you knew about the child and trusted your judgments, because that can come into play as well, making sure that they're supporting the educators at the table in their expertise and looking at that data for the decisions being proposed.
And just additional to that, the LEA rep can serve as the guardrail to keep, potentially angry parents in line and keep everybody on the agenda and keep everyone copacetic as we go forward and just try to do things in the best interest of the child.
So it is often that principal and that assistant principal. I know in my experience, sometimes we had a PE teacher, which was a little concerning, just who gets designated in that role. So again, just making sure that that person does have that knowledge and can really lead the discussions and facilitate and keep things on track. And it leaves those practitioners, the special education folks, to be the expert in that content and keep the IEP moving. But I think it's also just important that they understand those components of the IEP. A lot of times we'll get parents who are requesting things that may absolutely be something to be considered, but sometimes there's not data to support that request, and kind of having some trust in the data of your team members when you're making those decisions.
And sometimes we'll get things like, horse therapy or music therapy, kids moving from California, West Coast kids that maybe had that there, and we just don't have the data to support that, but you do have to make sure that the parental participation is given to the parents. So you listen to them, say we don't have the data on that yet, and then have the IEP team make the decision there.
Make sure that LEA rep is understanding where those guardrails are.
Exactly.
I think having those principals, assistant principals, building leaders there, it really does build trust in those parents. I think it shows the investment in their child. They appreciate the leadership of having that person in the role. And again, it allows your teachers to really focus on that content and the quality of the IEP pieces. But that knowledge of the curriculum is so critical. Also making sure that your teachers are proposing goals that are connected to content standards, that it's not that they're proposing things that are completely isolated to say a therapy or something. So making sure that connection is happening because they're content experts.
Yeah, parents can often come to meetings anxious or even antagonistic at times, with no fault to the IEP team of themselves on their own. So having that process there in place reassures parents that their input matters, and it helps manage their expectations for how a meeting looks and sounds, which increases their whole familiarity with the process and builds trust, and then building an IEP that can confer faith to the student.
All right, so this is what the leader needs to be prepared, that LEA rep needs to be prepared to discuss each of these. It's essentially all of the components of the IEP. And so making sure that you're able to speak to that student's progress, but also listening to the family about what the family's concerns and needs for their child are, so that is addressed in the meeting, and that there is collaboration and parental participation, and not just the school making decisions without that parent. But the present levels of educational performance, making sure that data that is brought to the table is discussed, there's collaboration, and that you're using current data to drive those decisions and keep the goals on the right path, as well as the services connected to the students' needs. The accommodations and access to general education, just from experience, I know sometimes in meetings, the accommodation section turned into a menu, and everybody's like, well, that sounds great, but if you don't have that data and you kind of can't keep that team on track, you're often offering things in an IEP that may not be based in data, may not be necessary, or may not be allocable by the district. And then also the special education services. I think it's critical if there is not a member of the team there. I think this often happens with related service providers. If they're perhaps an itinerant and they're not in that building, and then a proposal is made for a particular related service, making sure that those experts are brought in before decisions are made, because it may be that they have some data that wasn't presented in the meeting that would conflict with the decision that's being proposed. And then making sure that those related services are necessary that will help the student benefit from the special education services, and be prepared to talk about extended school year and not just the discussion, but what data do you have to support it. And then special transportation should also be addressed.
Unless this is an initial IEP team meeting, you're going to have an established IEP. You're going to have a platform to build off. So start there and remember that the IEP as written is appropriate if the student is continuing to make progress towards those agreed upon annual goals. With that IEP established as appropriate, you can use that as a catalyst for an amendment when one is suggested, whether the data suggests whether the IEP is working or not, if those goals are being met. And then you can add more services, less services, depending on what the student needs and whether that data shows that they need additional services. All right, we've got a little bit of a hypothetical for you guys, so I'll ask you to turn to your neighbor here in a second. But a fifth grader with cerebral palsy, I cannot read it on that screen. Fifth grader with cerebral palsy had difficulty speaking, lacked control over her movements, and required intensive assistance dressing, feeding, and toileting. She exhibited school refusal and avoidance, violent and unsafe maladaptive behaviors, and suicidal ideation, requiring 2 extended psychiatric hospitalizations. When the parent requested in-home services during an IEP meeting, the special education administrator determined that services would not be provided in person. She acted as the LEA representative and explained that she was solely responsible for making the final decisions for an IEP team. The parents filed due process. So can the LEA rep be the final decision maker if there's a question in the IEP meeting? Turn to your neighbor for a couple minutes and see what you all think.
Least restrictive environment for that child.
And really, I mean, that was a pretty good choice for not to be provided in person. I would definitely be doing something virtual too.
The interesting thing is
Does anybody want to be the volunteer and answer what they think would be how the court ruled in this case?
It's 50-50.
I heard that you act as a team. You're all there as team members, and it's good for everyone, like as the school team, to kind of be on the same page. Yes, we can disagree, but ultimately the ELA kind of has the final say. Now, I don't know if that's true, but that's what I've heard.
Okay.
Thank you for that answer. That is generally correct. This one, in this case specifically, the court ruled in favor of the parents because the LEA rep had told the team going into it that she had the final say. So it was already set up that they were going to be listening to her as opposed to coming up with their own ideas and acting as a cohesive group. But the answer in all these instances is, as an attorney, is usually maybe. Special education administrator is not solely responsible for making the team decisions, but they may have that ultimate decision authority. So in a case, student disability is an LRP case, the decision was made by a single participant, not a team, and the IEP team was not allowed to have an open mind. The court held that the LEA misunderstood the role of the administrator, and it was operating under the incorrect perception that the LEA representative made the final decisions for the team regarding the child's IEP. That's not how it should be done. It should be, as you said, a collaborative meeting where everybody, it not necessarily votes, but you want to have unanimity as much as possible. And that's why you want to have those clearly defined roles going into the meeting. USDOE has discouraged the idea of IEP teams voting when there is a disagreement between the teams. Generally, you want to maybe have a break and come back and re-adjourn. But if the school-based IEP team members do disagree, it's moving around. Then the IEP team can issue a prior written notice and implement the decision over the parents' objections unless a due process complaint is filed within 14 days. If the school-based IEP team members disagree with one another, then the team should continue to discuss with the goal of reaching a unanimous decision. If unanimity cannot be reached, then my advice would be either to maintain the status quo until you have more data to make and guide that decision, or for the LEA rep to make a decision about what your team should do. So that would be them acting as that ultimate decision maker. Good question? Get the mic over there.
So going back to your previous example of someone has moved in and they have equestrian therapy, okay? So would we still follow that because we can't reach a unanimous decision? Because maybe the folks there are like, oh, this is great. Are we going to maintain that status quo until we have time to gather data? Because we just don't, I don't think
Is
we have
this
the force.
assuming that the LEA does have like the resources for equestrian therapy?
That's the $1 million question.
Yeah, that would be the LEA representative's responsibility of like knowing the resources of the district and whether you can commit to that, because not every school district is going to have horses on hand to be given to every student. But you can, if the parents come in with that, listen to them, check out the data, say, we don't have the resources to do that here. And that's something that the team cannot have in the IEP because it's not something that can be done under our resources.
So if we don't have that existing, we're not compelled to try to collect data to see if we need to get that service, correct?
Correct.
Okay, thank you.
I would think they'll track data on what they are progressing on in their IEP
Exactly,
goals.
yeah.
You're providing those comparable, right, services and goals probably. And so, and say, you know what, we don't have that to offer, but they're making
But we have
progress based on
something
these
similar.
services that we are providing. Because it may be that that's a great bonus, equine therapy, but perhaps they're able to still make, progress without that.
Exactly. All right.
All right, effective meeting
Susan's
processes.
going to walk us through some tips.
And I know not every district, I know when I was back in a district, we actually went through facilitated IEP training, which I think was great, but I know not every district has that as a resource to have a neutral facilitator able to come to every meeting to kind of keep, like we talked about earlier, keeping things on track, remaining neutrality, establishing the ground rules. But there's a lot of just practical things that I think districts can do to kind of set the stage for a positive meeting culture. Obviously, it starts with that parental participation, making sure that parents are notified in plenty of time to be able to be there. Sometimes it's hard getting parents in the door, but just offering those opportunities and allowing for some flexibility in the schedule. I think when you can get in trouble is when you're saying we only do meetings on this time, this day, and not allowing parents an opportunity to participate meaningfully. Accommodate rescheduling when it's reasonable. Sometimes, you'll get those 10 minutes before a meeting, a parent cancels, and it's a lot to bring the team back together, and then it happens again. So, but, try to be reasonable if they're being reasonable. Making sure that those prior written notices following your meetings or any proposals or decisions that are made, make sure that they're in parent-friendly language. That is often so difficult for them to interpret, especially if it's filled with not legal jargon, but also special education jargon and acronyms that are unfamiliar to parents. I think it can create some, maybe perhaps not necessarily mistrust, but they just don't feel like they're on a level playing ground if they don't understand what's being presented to them.
Yeah, I would just say in those meeting invitations, just simple gestures such as calling the parents beforehand. They can go a long way to separate or creating that cooperative tone, which you really want. But just another note here, IEP team meetings can be rescheduled outside of that 10-day window only if the parties mutually agree. And you want to have it documented that the parents are mutually agreeing, because we've had instances where a complaint comes in where the parent has said that they're okay on the phone, that they would have the meeting outside the 10 days, but then they file a complaint with us and there's no evidence that they ever agreed to that. So just make sure you are documenting everything. We'll talk a little bit more about that later. Back to the question thing real quick. If the IEP team does decide that it is necessary for the student to receive FAPE, to have the equestrian therapy there, that's when you have to have the data and stuff. But that's why the LEA rep helps make that decision about whether that's necessary. Some more case law. I know everybody loves case law. So our first case comes out of Hawaii. So this was a failure to reschedule case where it resulted in denial of FAPE because the parents asked to be rescheduled and they would not. The LEA would not do that. This DB versus Santa Monica case, the district claimed that it needed to hold the meeting because the school year was ending, and the IDEA only requires the district to have an IEP effect at the start of the school year. So thus, the failure to review and revise the student's IEP before the beginning of summer break would not cause the district to run afoul of another procedural requirement. The parents' attendance at that meeting takes priority over the attendance of other members. So they had the meeting without the parents because the parents couldn't attend, and that constituted denial of FAPE. So they should have just waited in that instance. And then this Board of Education in Toledo case out of Ohio, you have to attempt to reschedule at least. Although the parents called to cancel the meeting, indicating they would reschedule, they never did. But this problem, the LEA did not reach back out to the parents about rescheduling. So when the parents requested an IEP team meeting to be rescheduled, the district should have attempted to at least identify another date, or at the very least inform the parents that it does plan on proceeding with the meeting should they not help engage in a rescheduling. Tip number 2.
All right, tip number 2. And I think Tate brought up a great point. Making sure that your parents just understand the processes ahead of them, especially if it's that initial IEP meeting or they're new to special education entirely. I think we take for granted it becomes just this rote process because you sit in umpteen hundred meetings a year, that it's just like, it's almost like assembly line, but sometimes these parents are not prepared for what's about to be presented to them about their child. So having that context and taking some of those steps initially to kind of, you just make them aware and educate them on the process and be a partner in that. Some of the tips for meeting preparation are just, use a checklist. And I think that helps parents as much too, especially if they're unfamiliar with what's going to be presented at the meeting. This is what we're going to do. We're going to do introductions. Here, we're going to explain your procedural safeguards. We're going to talk through the IEP as a team and make decisions about these things. And just doing that preparedness, I think, goes a long way. Gather that necessary data, your visuals, everything that you're going to be presenting ahead of time so that you're not scrambling and using time unwisely because everybody's time is so precious, and having that data already readily available if you feel like there might be a discussion and question about what's being presented, and setting an agenda for the meeting. And I think it's helpful to have it just posted in whatever conference room you typically use so that it is just standard practice that that's there and not just pulled out for those meetings. And then I think the next tip too is related to, what's the word I'm looking for? I think it's on the next slide. No, like the norms, but we'll get to that
we'll
too.
get to the norms.
Yeah,
in
we'll
a
get to
second,
the
but
meeting norms.
The norms are something you definitely want to have posted.
Yes.
I've got a couple examples of those.
Yep.
But just want to add a little bit here. Making that agenda can be important because sometimes parents come in with something and then they want to take you off track, and everybody's time is valuable. So consider the use of sort of a parking lot per se, for documenting the parents' concerns, obviously, and listening to their concerns. But then say, it's not on the agenda, so we'll park that over here for later for further discussion at a later time or after the meeting. But it's not here. What we're trying to do today is, amend the student's IEP and make sure that they have an offer of FAPE that is going to help them continue to progress during their IEP goals.
All right.
Tip 3.
So I hear Taylor Jenkins' voice in this one all the time in bullet number 1, because I think people are afraid to have discussions in advance of a meeting saying, oh gosh, that's predetermination and the parent's going to come back on that. But there is a distinction between preparation and preparatory meetings and predetermination. So as long as your team is coming together and having some consensus before you come to the table, especially if you think that there's going to be some contention at the meeting, that's okay. Just don't walk into it with a decision made. Make sure that when you are all coming together that you are still including that parent, and still acting as a team rather than as the school versus the parents. And please don't finalize the IEP before a meeting, and particularly now in the age of Tea and Pulse where you can't go back and take it back. That also would be predetermination, right? If you're finalizing that and the parent has yet to agree to it. Share all of the drafts in advance, not only the IEP drafts, but now the rule is it 199, Public Chapter 199?
Public Chapter 199.
On evaluation, so making sure that those parents are getting all those drafts in advance so that they have opportunity for meaningful engagement and some preparation on their end. Mark it with a draft as you send it home. Again, that makes that distinction that you haven't made a decision as a school. We're just sharing a draft that we're going to discuss as a team when we come together. And then certainly document any changes from the parents' input. So as you're talking to them about, share with me what your concerns are, making sure that you're documenting that and considering it.
Yeah. The point is that parents need that genuine seat at the table. So definitely, like Susan said, document how the school team members are listening thoroughly and considering, discussing those parents' requests and concerns, even those that may seem unconventional. The difference between preparation and predetermination is that opportunity to have those discussions at meeting. For example, it is predetermination if a 1-versus-1 para is not determined or decided at an IEP team meeting as district personnel hadn't completed. This question, is it predetermination if a 1-on-1 para is not determined or decided at an IEP team meeting as a district personnel hadn't completed the paperwork? No. Like any IEP support or service, there needs to be educationally relevant data to support that decision. So just because it's not decided there, then you generally know that predetermination when you hear it. So without having any discussion, it sounds like very much like take it or leave it. And that's what you want to avoid, is a take it or leave it scenario. You want to have that genuine conversation with parents so that they feel heard and that their input is actually being considered.
I think that's where your LEA rep is so important too, because oftentimes I know I've sat in meetings and I'm sorry, we can't do that. We don't have that. And they're already making a decision without the consideration component. And so making sure that those LEA reps are informed about the things that they shouldn't say.
Whether it could be possible.
Right, exactly.
Somebody have a question?
Yes.
So the school psych evaluations have to go home with draft on them also?
Evaluation.
Does it have to have the draft watermark? I think it's a good idea to have a draft watermark on it, but I don't think there's anything in the law that requires that it be a draft watermark. Yeah.
Just make sure the IEP is.
Because it still theoretically could be changed once they come, if the parent disagrees with anything, or is it just a mistake that's identified within it, there's still opportunity for revision.
Oh, we have another question?
I thought so, but maybe not.
Okay. Tip number 4.
Alrighty, establishing the norms, and this is what we kind of talked about. I think just having those standard practices at every meeting. I mean, often the ones that are going to be challenging, but even the ones that you think everything is copacetic sometimes can go a little bit sideways. So just having those norms and establishing it as a common practice in your district is just good practice for everyone. And then I think it just builds that familiarity with these processes. So establish and share those expectations. I know in the school district I work for, we actually had them posted. We even had like the parking lot for a while. And then, as you know, that some parents might be unhappy in a meeting, let's say. And so making sure that you're kind of establishing those norms for behavior, and we've got a couple of examples of those, and just abusive behavior should not be accepted on either party. Sometimes it does require taking a break. Sometimes it requires halting a meeting altogether, but maybe just a little breath of fresh air and coming back together. But if you've already established those up front, you can kind of point to it. Well, we already talked initially, we set our norms, so we're gonna just take a break for now, or we're gonna need to reconvene at a later time when we can come back together. So just having that already prepared is helpful.
Yeah, it's not just the students that have had sort of behavioral issues after COVID. We've seen it at sporting events and other things that some people, sometimes they forget their manners. So if that happens and you are having sort of an antagonistic moment, call for a short break or a meeting recess, or just adjourn the meeting and reschedule. But limit their ability to abuse or verbally, or hopefully not physically, any of your staff members. That is completely unacceptable. And if it needs to, maybe restrict the parent for only attending virtually. That's something we've seen happen, but that should be just in the most extreme circumstances. So some examples of meeting norms, we actually got these directly from an LEA, and these, we thought they were fantastic, so I wanted to share them with everyone else. The first, all meeting participants should be treated with respect and in a professional manner. Personal attacks, raised voices, and disrespectful language are unacceptable and may result in the meeting being paused or rescheduled. Again, we're all here for the same purpose of helping the student, helping them progress, and make sure you remind people of that. So these are good things to have posted on your walls, so when people come in, maybe they read those as they're waiting and are more aware of the expectations going in. All meeting participants will listen actively and consider each other's perspectives and input. Active and respectful listening aids in understanding each participant's concerns, finding common ground, and encouraging the team to find solutions rather than assigning blame. Again, keeping that spirit of cooperation is important. So in the event that more time is needed to complete the meeting, the team will reconvene as soon as possible. And when possible, the team should reschedule the subsequent meeting before the conclusion of the initial meeting. So just some things to keep in mind so that parents, especially new parents, if it's an initial IEP team meeting, so that they're just aware of how things go and how a typical meeting should look. And as any situation with adults, we should always treat each other with respect. But in instances when kids are concerned, sometimes emotions get involved, and you just want to make sure that you have the parameters in place so that the parents know what the expectations are going into a meeting.
And I think bringing it back to the student, because you hope that they understand that the school has that student at heart too, and that you're working towards a common goal.
Exactly.
So getting everybody to have agreement even when you're going in, I think is helpful.
So implementation of the IEP. When must the IEP be in effect? Must ensure that as soon as possible following the development of the IEP, special education and related services are made available to the child in accordance with the child's IEP, and that comes from our Code of Federal Regs there. So delay in implementation may rise to a denial of FAPE where the student is denied a significant portion of services as prescribed by the IEP. If the parent doesn't sign the IEP, though, and is not in agreement, that needs to be a 14-day waiting period for after when the IEP is finalized at the meeting. You need to send the prior written notice within 10 days, and then 14 days after you send the prior written notice, that's when services can be implemented, because you want to give the parent that opportunity to file due process just in case they want to challenge a decision. When it must be in effect. At the beginning of each school year, each public agency must have in effect for each child with a disability within its jurisdiction an IEP. If an IEP has not been finalized by the end of the prior school year, the LEA must meet with parents during the summer. So the failure to have an IEP in effect at the beginning of the school year could also result in a denial of FAPE. Possible exception may avoid liability for failure to have an IEP in effect by the start of the school year where the district has met significant resistance from parents. If they're not agreeing to come to meetings, this is probably for a reevaluation. Obviously, if the parent doesn't consent to initial services, then there can be no services. But if you're meeting extreme resistance from parents, it may be an exception to having it in effect at the beginning of the school year. But you do want to try to reach common ground with them as much as possible to get that in effect. Got a question?
Yes, I have a question. The phrase about a child with a disability within its jurisdiction. So there are children who do not attend the public school.
Of course.
With disabilities, and so would you address examples of that, or?
Sure. So say you have a child who lives in Davidson County, but they go to private school in Williamson County. So Williamson County, since they're around the student more, would have the affirmative child find obligation there. So they would have the obligation affirmatively to initial evaluation. And also, if a parent requests an evaluation, it could be either LEA could be responsible. And it's happened before that a parent has requested one from each LEA. And under DOE guidance, US DOE guidance, both LEAs do have a responsibility to conduct an evaluation in that circumstance.
So does the primary responsibility lie with the school where the child attends, or
Yes.
where the child resides?
So it depends. Where the child resides has the responsibility for the offer of FAPE. Should a parent want to re-enroll in the public school system, you have to issue an offer of FAPE. Unless the parent has made it very clear that the student is not coming back to public school, then you do not have to issue that offer of FAPE. The LEA, where the private school is located, that they would be responsible for equitable services under an ISP.
Okay, thank you.
Individual service plan. Individual service plan, there are
Yeah, individual
using
service
our
plan. Yeah.
SPED acronyms.
So who's responsible for implementing the IEP? Anybody? Everybody, good job. So if you're sitting here today, you're likely aware that there's a big conversation about who's responsible to modify that gen ed curriculum, classwork, all sorts of things. But if your special education teacher is responsible for accommodating end of unit quizzes, tests, how far in advance will they be provided, or is there planning time for those tasks to be done together with other members? But every regular education teacher, special education teacher, and service provider is responsible for implementing the IEP, and they have to understand how to implement it and be informed of their specific responsibilities for that implementation.
And I would say going back to making sure everybody understands their roles and some of those pre-planning meetings, that general education teachers aren't there just to be present, but truly to act as a member of the team and talk about how that student's performing in the classroom, any concerns, or maybe this accommodation is working or isn't working. So kind of empowering them to have that voice at the table, because I think often it's led by the special education teachers rather than a collaborative effort. Not in every meeting, but I've seen that. So I think making sure too that LEA representative that there is including those gen ed teachers, getting that perspective, because they are the content experts.
Yep.
This
includes substitute teachers. Did not know that I had to click that one. Is this me or you?
I think it's you.
Okay. Ensuring implementation of the IEP. Have all your teachers in attendance sign the IEP. If paraprofessionals also share responsibilities, have you documented that they have been given coverage and outlined how they're supposed to be implemented? So once an IEP team has met and developed an agreed upon plan, there are several responsibilities of the LEA to make sure it is implemented. Review and sign that IEP, like I said, all teachers in attendance. Then coordinate and oversee the provision of special education and related services. This can include scheduling, facilitation of collaborative planning, coordination of required transportation, ensuring special education interventions and services are being appropriately implemented.
Can I say too, real quick,
Please.
Tate? I know we have the IEP at a glance on Pulse, and it's great, it's super high level, but make sure that your teachers, if they weren't present, have reviewed the IEP in its entirety, rather than just relying on that at a glance, because it doesn't capture every component of all of the decisions made.
Yeah, and make sure that you've done resource mapping, that's occurred to provide coverage that's outlined in the IEP. Number 3, ensure each team member understands their roles and responsibilities in implementing the IEP. Document efforts to show that the teachers were informed of their responsibilities to implement students' IEP and provided access to that IEP, the portion of the IEP that they would be responsible for. 4, commit and provide resources as determined appropriate. And 5, promote instructionally appropriate services that are responsive to the student needs. For example, did you agree to a more sophisticated assistive technology device or software? What training are you committed to providing school personnel that they're able to implement that with fidelity? So read the deliberations, provide the full story of what was offered or needs to be provided, and pay attention to all those addendums and attachments to an IEP as well.
All right, documentation. You've always heard that, if it's not documented, it didn't happen. And there's so much to document these days, but it's so important and it's such a protection for the LEA to have thorough and accurate documentation. And effective documentation, we know that that's important. Inconsistent or inaccurate documentation may create problems, and that's where if it comes to an administrative complaint or comes to Tate's office, that's the first thing that they're going to ask for is the evidence. And it could be data sheets, it could be attendance logs, all of those things. So making sure that those pieces are collected and accurate. And it can impact the outcome of an investigation if it gets that far.
Yeah, when we get administrative complaints or if it goes to due process, having that hard evidence is the best defense you're going to have against a complaint from a parent or from an advocate. So definitely important to document all the time.
And what should be documented, it feels impossible to document everything, and truly it is. And I think one piece of this is, the families, the students for which it's critically important for you to document every moment of that child's day. And obviously you do the best you can, but this is, again, going to be your defense. I think accommodations is a biggie, and not only if it turns into an allegation or a denial of FAPE, but also that you have that data that you can bring to the next IEP meeting and say, you know what, we've given him read aloud for the last 3 years, but we've got this other data to support that, one, he's not using it, he's doing well when we've attempted it without it. So just having some resources and supports when you come to the meeting that you can defend any proposals or changes that you have. Your related services minutes, again, making sure that if it's documented as an IEP or a related service, that you've got documentation that it happened. I remember being in a school district when I had to turn over all of those things, like my data sheets, my attendance logs, and everything. And it's a lot to gather, but it is defensible if you've got it. Participation with general education peers. If the determination is that students' LRE is that they're participating with general education peers, make sure that you've got evidence of that happening. You know, what do the schedules look like? Certainly progress towards IEP goals and objectives. Obviously, you've got the progress reports, and those are going to be helpful if they are substantive and you've got good data rather than Johnny's doing great, we're going to keep working at this. I think that would probably not rise to the level of defendable data. So making sure that you have actual quantifiable data to share with the child's advancement towards their goals.
Yep, or copy pasting the same sentence for 3 straight times for progress goal monitoring.
Or that I'm expected to meet the goal, and then at the end of the year, like, didn't meet the goal. So
something was off there.
Yes, making sure that you've got some consistency there. Transition services, if those are in the IEP, make sure that those are happening as documented. And then, of course, assistive technology. If that's written in the IEP that this child needs assistive technology, have that evidence, that data of one, not only that it's been available to the student as written in the IEP, but how are they doing with it? Is it an effective assistive technology? High tech, low tech? Is it something they still need? Do we need to consider a different type of device or product for this child based on their progress? Behavior intervention plans, that's critical. If you've got good behavior folks, they are excellent data collectors, but making sure that everybody across the team is also using that and collecting data with fidelity. And then compensatory services, which I know we're going to touch on here in a little bit, and we'll dig into comp ed, but making sure that if you have agreed to compensatory education, that you're documenting when that has been provided to the child. And then accelerated instruction. You want to speak to that one, because I'm not.
Just if the student does have accelerated instruction, make sure you're documenting those needs. Sometimes for gifted students, that's important. Also, I just want to say it's generally wise to document communications with other staff members about any of the student's progress, but be mindful because every document may be used in litigation, so mind your P's and Q's. Just know that a parent could request this through a public records request. So even if you say something in jest, it may not always have that same tone when it's there in black and white in print. So, but as Susan said, is it feasible to document every single occurrence of an accommodation? No, it's not, but you just want to do as much as possible to make sure that should a complaint or a due process be filed, then you'll have the ability to defend that.
All right, and who's responsible? Kind of, again, everybody. Everybody that's a part of that IEP team, the special education teachers have their own data that they're collecting towards their services and their goals, but also the general education teachers, again, critical members of the IEP team. Make sure that they've got data that they're bringing to the table about any curriculum-based measures or just how they're performing in the classroom, what are peer interactions like. There's so much that you can bring when you're having those discussions and making decisions about services for students. But administrators, and I think from the morning session, I really liked a lot of what they said, making sure that the services are being delivered as written and that what's happening in those classrooms is quality service, right? And that the students aren't in there, as we heard earlier, cleaning tables when they should be receiving interventions and services. Be consistent, detailed, and professional. You never know, as Tate said, what might be used as evidence. So yeah, I think, and this is a question that we often got as practitioners for data, can they collect your notes, like your own practitioner notes about students? And I think the answer is yes.
It can be if it's student specific, yeah.
Yep.
So while documentation is time consuming, and I know it can be a pain, I don't like putting my time into the Edison website every 2 weeks either, but it is far less time consuming than having to defend a due process claim. So Just make sure that you are doing that to the best as possible. And also because it can come up when we are discussing compensatory education. Transition. Say you've committed to services that are in an IEP, but you don't actually have the resources for that and have missed providing services a bit. That's a good time to start thinking about compensatory education. So compensatory services, or comp ed, which I may use as a shorthand going forward, may be due regardless of whether it is a substantive denial of FAPE, failing to evaluate, failing to implement, failing to ensure adequate progress, or just a procedural denial of FAPE, which may be just failing to allow parental participation. But whenever an LEA has not met its obligations under the IDEA, included, not limited to, that failing to evaluate, implement, progress in appropriate circumstances, or procedural violations, that's when comp ed should be considered. But do remember that there are those 10 FAPE-free day rules. Courts have been usually only determined that there has been a deprivation of FAPE if services have not been provided for more than those 10 days. Over the school year. However, I do think LEAs want to be proactive about those shorter periods of time if students have missed services, just to keep that familiar cooperative tone with parents to be like, hey, we missed a couple days here. We're going to offer you these speech services in lieu of the ones that were missed. So legal foundation for compensatory education. Interestingly enough, the IDEA itself does not expressly identify or explicitly use the term compensatory services at all. It's a judicially created remedy. The courts have utilized comp ed as a remedy to grant relief that the court determines appropriate for the student. Basically, comp service was created in a way to get the student where they would have been but for that violation of special education law. So the purposes of compensatory education is to award a remedy for the denial of FAPE or other violation of special education law. It's an equitable remedy, not meant to be punitive at all. The goal is to place the student where he or she would have been but for that violation. There's two general approaches. There's no real one correct way to calculate the appropriate services for comp ed. Two possible approaches are an hour-for-hour approach. This would be the LEA provides special education and related services to the student in an equal amount to the time that the student had missed. That hour-for-hour approach is useful in the smaller circumstances when they miss a small period of time for their services. For example, say a student misses 2 weeks of speech services. It's likely a lot easier to provide 2 weeks worth of makeup services rather than having to calculate where the student would have been if they hadn't missed those 2 weeks. On the other hand, the totality of circumstances approach is so the LEA provides special education and related services to the student in an amount that is designed to ensure that the student makes the same amount of progress that the student would have made but for those missed services. This approach is useful for those larger periods of time when the student has not received any services for several months. For example, if the student is not provided specialized instruction from a properly endorsed teacher, it is better to practice to judge that impact of the services rather than saying we need to provide all of those same services all over again. Those are the two approaches, and I'll walk you through a case that kind of goes into the difference between the two. So this was a case out of DC. A due process hearing officer had determined that the district denied student FAPE for 4.5 years. And so the due process hearing officer awarded the student 810 hours of compensatory education comp ed, 1 hour for each day the student had missed. The parents argued that the due process hearing officer's award was not based on logic or evidence, and they wanted 1 hour for every hour. They wanted the hour-for-hour approach. But neither the hearing officer nor the parents based their proposed amount of comp ed on what the student actually needed. Neither calculation was based on a review of the student's record or what the student needed to get back where they would have been but for those violations. So the court ended up holding that there is no obligation to provide a day-for-day compensation of the time missed. Appropriate relief is designed to ensure that the student is appropriately educated within the means of IDEA. So the award for past violations must rely on individualized assessments, just as an IEP would be focusing on an individualized student's needs. So in this instance, neither the parent nor the hearing officer had the right approach. We don't have to provide hour-for-hour compensatory services. Determinations must be made just about the student's needs. And in this case, the takeaways we want to take away from this is The IEP team could determine that the student needs less compensatory services than the amount that they were missed. For example, the student has progressed quicker, will progress quicker if the services are provided in a higher dosage or in an environment with a lower student-to-teacher ratio. But they could also, the IEP team could also determine that the student needs more compensatory services than the amount was missed. And this would be, say, a student has progressed in their reading ability or regressed in their reading ability due to the missed services and now needs additional services to not only catch them back up where they would be, but catch them back up where they were before they missed the services. So in that instance, you would need more than most missed. But you should craft this compensatory education services by treating them as individualized, student-based, and then violations of special education law could result in no comp ed unless comp ed or more comp ed. So those scenarios I just mentioned are good examples of that.
And I would say this goes back to the data piece too. That's why it's so critical, especially to have data on your goals, because that's what's going to be used as kind of your baseline of where were they before we were not able to provide services, and then where are they now? And because you really kind of need to have that as your foundation and your baseline when you're making those decisions. So again, back to how critical that data collection piece is, the documentation piece is, which goes back to making sure that your goals are measurable in the first place, because it's also very hard to collect data on a goal that isn't measurable to know whether or not that student had made progress.
So again, calculating that comp ed, just go back to that NGRF standard. LEAs have to offer an educational program that's reasonably calculated to have the student make progress in light of their circumstances. So how do we know what appropriate progress is? By looking at the information we already have on hand, the ones we've documented. What are the grade level standards for the student? What are their areas of exceptionalities? Has he met his annual goals? Courts are going to defer to an IEP team's education and experience as long as it is reasonable within the circumstances. So, reminders and tips. First tip, compensatory education must not replace the student's current educational program. We can incorporate compensatory services during the school day, but they should not take the place of any core academic classes, electives, or tiered intervention or other educational opportunities, because these were services that should have been provided initially. 2, compensatory services should not be documented in the IEP. They have to be separate. Otherwise, you're generating funding for something that the LEA has already gotten funding for, and that could result in an audit. So you don't want that to be flagged for being double funded. 3, talk about scheduling early and often. Be creative with your approaches. Document parent refusals. Oftentimes, parents don't. Can we scroll down a little bit on the notes too? Oftentimes, parents don't want to have a student come in after school or on summer break or winter break, but make sure you're trying your best to be open-minded and collaborative with parents as much as possible, but definitely note their refusals and keep those documented. We've had closed corrective action plans where an LEA has made good faith showing that they have tried to reach out to the parents and offer these comp ed services, but the family did not accept the services, and so we closed the cap based off that. Number 4, compensatory education may be required when the student is no longer eligible in your LEA. So the LEA who was responsible for providing the services that were when the violation occurred will be responsible. So if a student moves to a new LEA or enrolls in a non-public school, the original LEA is still responsible for providing those comp ed services. The original LEA can meet its obligation by sending staff to the new LEA, hopefully if it's a neighboring district, or contracting with that new LEA to provide services, or even a third party to provide those services. 5, be proactive in offering compensatory education when you know that the student did not receive services needed for FAPE. Comp ed makes providing FAPE easier. Our ultimate goal, as we mentioned, is for students with disabilities to perform at grade level and to no longer need special education. The best way to do that is by ensuring that students receive all of the services listed in their IEP. So proactively offering comp ed will help the student increase transparency and have more trust with the family, and will also help the LEA's accountability measures when that comes around. 6, if compensatory education is awarded by TDOE through an administrative complaint or through FPO monitoring, we expect you to decide an appropriate amount of compensatory ed through the IEP team. Make sure you are following IEP team procedures. Follow those procedures, send out an invitation to the meeting, and get that parental input, and then issue a prior written notice about how much comp ed has been determined. And finally, number 7, if compensatory education is awarded by an administrative law judge through a due process hearing, the IEP team cannot overrule the judge. Be prepared to present evidence of the student's needs at the hearing. So even if you feel confident that you will prevail at a due process hearing, make sure that you are presenting evidence, in the alternative that you do not prevail, of the amount of compensatory services that the student would require if the hearing officer rules in favor of the parents. Otherwise, the court will have no evidence on the record to rebut the parents' arguments for, say, they wanted an hour-to-hour approach. That's often what they will want. All right, any questions on that before we turn to our last topic for least restrictive environment? Cool. So the importance of least restrictive environment, while it may seem in the moment more easy to place problematic students in a more restrictive environment, it may seem prudent in the moment, it's not always the right choice for a student. Socialization, learning from another's peers, it's essential for students with disabilities to learn how to function by mirroring their peers and learning how to behave around them. For instance, sometimes it's a lot easier, rather than telling a student not to run down the hallway, they see the other students not running down the hallway and they act accordingly. Mirroring their behavior can be more effective for a student as opposed to just hearing it from an authority figure. So hopefully this can shed a little light on the importance of LRE and how we're going to make those decisions going forward. So students with disabilities must be educated alongside their non-disabled peers to the maximum extent possible. Students with disabilities must be removed from the regular education environment only when the student's IEP team determines that the nature or severity of the student's disability is such that the education in the regular classroom with the use of supplementary aids and services cannot be achieved satisfactorily. So IDEA requires us to exhaust those supplementary aids and services to try to keep that student with their general education peers. Can we support the teacher with more classroom management? Can we support with other accommodations, maybe preferential seating? What about one-on-one aids, small doses of pull-out services, assistive technology, etc. Try your best to keep the student in their least restrictive environment around their general education peers, because the key is we want to make sure that we have the students in the best place possible for them to grow and progress to eventually become active members of society. Some examples of services, we have instructional supports, modified assignments, repetition, I kind of listed these earlier, assistive technology, environmental supports, preferential seating, minimalized visual or auditory distractions, use of quiet corners or calming areas, visual schedules, posted daily routines. Another thing you might want to do is you could always reach out to Triad, which is one of our state supports. But behavioral supports can also include, does the student perhaps need an FBA conducted? Do they need a behavioral improvement plan in place? Those are things that you want to look for when you're trying to see if you've exhausted all those services before considering a more restrictive environment.
Can I interject one thing
Please.
too? So just thinking through the least restrictive environment, I know with the staffing shortages, it's challenging and a lot of districts are relying on contracted folks to come in. They're often operating under a more medical model, and if they're coming to IEPs and representing as that professional or specialist, they often defer to a pull-out situation or a more restrictive situation. So just making sure too that they understand the expectations of least restrictive environment and that those decisions aren't being made in isolation from a third-party contractor.
Okay, so say you have been invited to an IEP team meeting. The student is 5 years old and has been enrolled in TEIS, the Tennessee Early Intervention Services extended option, since she was 3 years old. Your school psych suspects that the student may have an intellectual disability, but the student is currently eligible under the disability category of developmental delay. The TEIS case manager has described the student as a handful, buzzword, who is unable to follow directions, routinely throws tantrums, or has had issues with biting adults and peers. So two questions. First, what sort of documentation would you want to feel confident in your decision? And secondly, must the student's IEP team place the student in the general education classroom as soon as she starts? Talk to your neighbor for a second and see what you all think.
more than foster care.
All right, so what kind of information would you want? What if it's a student coming from being homeschooled? What kind of information would you want?
In a case like this, maybe there would be observations from maybe just anecdotal notes about how they were in Sunday school or when they do their play therapy group.
Great.
That idea of describing a student as a handful, what does that mean? Were there any other peers around, or do they live solo?
So the biggest issue here, you'd say, is maybe a lack of data.
Right.
Right?
So we didn't get to the part of must the student's IEP team place them. I think we're kind of going towards we should if we don't have evidence to the contrary.
Yep. So that lack of evidence is going to be your biggest hurdle here. I mean, you don't even know how the student might respond to academic instruction if they haven't been, in a more structured environment. But yeah, this would be a tough decision for an LEA. The answer comes in, what you can do to conduct an evaluation, a reevaluation, gather that more data. But the answer from DOE is that first consideration must be given to a placement in a regular education environment. OSEP does not interpret Part B's LRE provision to require the disabled student be placed in a regular classroom and fail before a more restrictive placement is considered. So it has to be considered first, but it's not required to place them there. You make the decision with the IB team, have a reevaluation done, and then come to that decision and explain it thoroughly in a prior written notice. Placements can be based on things other than where the student will receive the best education. It's what is best for them. But thinking about all these factors together, then make the decision. One of those factors you should consider, and for this instance would be age, because you don't have that data. But another reason for this next slide, age being a factor in placement. What is considered an appropriate placement for students will often depend upon the student's age. With those younger students, you want them around their peers more because mirroring behavior is much more beneficial for those younger kiddos as opposed to a student that may need more pre-vocational training in a more restrictive environment. Courts have generally upheld more restrictive placements for students with disabilities nearing high school age, nearing high school, because of the lack of data at a young age. More data can support your decision for a more restrictive environment at an older age. Again, that importance of socialization at a young age versus that pre-vocational training or programming at an older age for the student as they leave high school and enter the community.
And those 3 to 5-year-olds are all learning behaviors and how to be, in school and what that looks like. So, and I think too, if you start on that more restrictive setting when they're younger, that often keeps them on that trajectory for a more restrictive placement. It's hard to make the case when they're receiving 7 hours of services in preschool that they're now going to kindergarten, and you want to pull some of that back because the programming looks different. So making sure that those services and those decisions about placement are made with some data again.
I've got a 4-year-old, and that last example with the 3 to 5-year-old that was exhibiting biting, that is a very common age-appropriate behavior. So it may not be as much of a red flag as it would be at a later age. But so just make sure that the age-appropriate behavior is taken into account, but that can be a factor that courts look at if they're reviewing a decision. So when is placement in a general education classroom not required? There's this case that came out of our circuit, the Sixth Circuit, called the Ronker test. And there's 3 reasons why you can take them out of the general education classroom. First, no educational benefit. The student would not benefit from regular education at all. This is a very hard argument to make. Like I said earlier, the importance of mirroring behavior, it's success, education is not just synonymous with academic benefits, those socialization benefits, things outside the classroom, other things to prepare the student for life after school. So LEAs are generally not successful in arguing that a student will fail to receive any benefit from regular education. The middle column is probably where you want to land. That's that marginal educational benefit. Courts, generally, if the benefit of the placement in a regular education classroom would be far outweighed by the benefits of special education, courts generally rule that that's going to be a successful argument. LEAs have had success in arguing that a student will be better served in a more restricted environment. But note that the benefits of a more restricted environment have to far outweigh the benefits of a less restricted environment because of those non-academic reasons that a student could benefit. And the last reason, which we'll touch on in just a second, is disruptive force. And this is not just class clown, a student being disruptive. This is a status that it has to basically disrupt in a classroom's entire overall functioning. When is a student a disruptive force? And I did not want to have any specific kid's picture up here, so this is an AI kid. But when is a student a disruptive force? Courts have generally held that a student is a disruptive force if one of these following is true. And the first two kind of are together. So the student's behavior is interfering with the learning of other students because the student demands so much attention of the teacher's time and attention. And also the student's behavior interferes with the learning of other students because the student's behavior is a distraction to classmates. Generally, these go hand in hand. If they're taking too much time away, that can be distraction. But we've seen instances where a classroom has had to be cleared on multiple occasions because the student's throwing chairs, and it's the obligation to provide FAPE to all students, not just that one most disruptive student. And that can mean that it would be beneficial to move that student to a more restricted place for a period of time with the knowledge that the goal is to hopefully bring them back once you maybe have a BIP in place to help them be more comfortable in socializing and behaving properly around their peers. That third one is if the student is threatening the safety of themselves or others placed in a regular education classroom. That's something you kind of know it when you see it. We'll give an example here, more of an extreme example on this last slide coming up. But yeah, if they're putting themselves or others in harm's way, that's when you want to move to a more restrictive setting. And you no longer have to wait on a BIP or an FBA to be conducted in order to make that move if the student's safety is posing a concern.
I'm curious if these same practices would be implemented for students that have not yet been identified with a disability. So we have a lot of these very young students where they're just walking into the classroom and these behaviors are on from day one. So how would this be implemented for those students?
So that would be a red flag that the student would need to undergo an evaluation generally, but you wouldn't be removing them to a non-special education. You wouldn't be moving them to a more restrictive, isolated special education classroom until an evaluation is conducted.
I would collect that data though, because that'll be part of your evaluation data that you bring to the table of even before we've gotten to this referral, we've had to clear the classroom, we've had to do all of these things. This has been effective, this has not been effective.
And that can occur especially with young kiddos coming into kindergarten, first grade. And those are the red flags that are setting off. This is not just a one-off instance. This is a pattern of behaviors that raises a red flag that we need to have an IEPT meeting, have our child find procedures started. You have another question?
I know you have to have the data to prove like the kid has been disruptive, but how much data do you have to have?
So there's not a black and white hard line test on that. Unfortunately, I wish we could say X amount of data, you're good, but that is something you're going to have to discuss with your local board attorney, your special education directors to have that decision in place. But generally, if it's a pattern of behavior and is continuing to disrupt the time that other students are receiving education, say, this one classroom is 2 months behind on their reading schedule because of a student, or maybe not want to wait to get to that point, but just have all the data in place so that you can feel confident in defending that decision should you have a due process case filed against you.
And if you're lucky enough to have behavioral specialists, you don't have to wait until the child's eligible to get their consult and have them come in and conduct observations. Mm-hmm. And then if this child is still considered gen ed and hasn't been identified, what has been attempted, what was successful, what wasn't, because all of that would be considered when you come to the table and say, okay, we really might need to look at special education
or a more
eligibility, or a different placement.
Yeah. So here's an extreme case scenario, came out of Knoxville in 2017. This student in one day had over 50 instances of groping and hitting staff, threw scissors and magnets at students, even pushed down a student with a degenerative brain disease, was spitting on classmates, pulling their hair so often that other students would pull their hoods up when the student walked by, And several of her classmates were so anxious about having class with her that they had to speak with the student's counselor about coping mechanisms, about how to handle that. And on most days, the school needed 4 or 5 employees in that classroom to both teach that student and her classmates, including 2 paraprofessionals just for that student. Don't wait until it gets this bad. I love what Knoxville did. They have all of this documented, so when a due process case was filed, it was so clear for the court that this student is not at this time able to function around her peers, and she's clearly being a disruptive force. But don't wait till it gets to this point. Contact your special education director and discuss what steps need to be taken place. Maybe contact your board attorney and say, look, we've had instances of X, Y, Z. Here's our document of this. Should we move the student to a more restrictive environment? Question?
So to her point, was IL already identified when these things happened, or is this part of the child find data?
No, she was identified as special education prior
Oh,
to
okay.
all this, yeah.
And so then this was used to move more restrictive?
To leave the general education classroom and go to a more restrictive,
Okay.
isolated setting.
Okay, thank you.
So this is reality in elementary education, sadly, but we're not built with the other placements at this time. So what are recommendations for other placements? Because we are in that, we're going through the data, we have a behavior consultant, we do have everything in place that you've mentioned, but now we have this data to say that we have a severe behavior. Where is our next restrictive place for this child if we don't have that right now?
Do you have a continuum of placements though? So you've got gen ed, and then are you saying you have gen ed, and then you have like a special ed classroom, and those are your 2
So we have
considerations?
gen ed, inclusion, and that's it. And we have a severe and profound room with students that are,
Right.
but the academically, the child is a high-functioning student with no identified disability at this time, besides the behavior challenges, although we're going through the testing we have the FBA, we're going through all of that. To develop a BIP, we're trying to find eligibility. That's where we are.
Yeah. Do you have, I know when I worked in an elementary school, I had a similar, I wasn't in Knoxville, but it felt very similar to this case. And we had luckily enough, there was a whole classroom that was empty, and that's where this student spent a good portion of their day because it wasn't safe even in the other classroom that was more of the comprehensive special education classroom. But it is the district's obligation to provide that continuum of placement. And is in this case your student already a student who, you said you're collecting data, is he already identified, or this is a general education student currently?
He came to us from a Head Start program.
Okay.
He was identified early on with some, behavior concerns that I don't think he even finished in Head Start. So now we're looking at a kindergartner who struggles.
So you're evaluating them currently for the behavioral disability?
Our school psychs have this, and it's in their hands right now. We're in that, waiting period, collecting all the data. We have tons of data it's very similar to what you have on your screen. So we're to a very high level, but we're not identified yet. So we can't do anything.
If they're posing a risk, a safety risk for themselves or other students, I think you'd be safe in putting them in a different environment.
Okay.
Because you want to, first and foremost, make sure that everybody's safe, including the other students and the student themselves.
Luckily, right now, it's not other students. It is staff. So that's where the same safety is a concern. So.
I have a question.
Yeah.
Would you talk about student confidentiality and student records, special ed records, IEPs?
Sure.
Who has access? Would you talk about that, please?
Yeah, sure. So the law guiding that would be FERPA, and I don't have all of my notes on that in front of me, but specifically, if the educational record is being used for an academic purpose, between giving it to another teacher, or that's all going to be covered. That's going to be fine as long as the record is being used for an educational purpose, right? But do you have a specific instance or example of when you're concerned about? Or
Who has access to the record?
it should be only employees of the school.
Okay.
Yeah, only
And the
school
parents can
employees.
request
And the
to
parents can
invest-
request
to,
the
inspect.
records, yeah, to
Okay.
inspect. They have a right to respect.
Okay.
Inspect.
They should have an educational interest in that child,
Yes.
right? So it should be somebody who is working with that child, or maybe somebody who is on the referral team that is doing
Somebody
some
that's involved with that
observations.
student
Right,
should have
right,
that.
but not just anybody.
Not just, no, not
Correct.
the janitor having access
Correct.
to,
Kind of like when we were talking about earlier about copies of the IEP,
Thank you
we
for that
discourage that being just copied and handed out. You know,
Yeah.
certainly if those gen ed teachers, you want them to have the opportunity to review and understand that IEP, but it shouldn't just be stuck in a file cabinet and left
Yeah.
accessible for
So
people.
employees that do have an interest in the student's academic education.
It is only the teachers that are actually teaching the student that year, but we give IEP at a glance to any teacher that's teaching that student that year, and any aide that is a special ed aide that's working with that student, and the special ed bus driver if they're working with that student, and there's
Yeah.
accommodations that need to go there. We also have them sign that they've gotten an access of that on the IEP and on the records form, so that the parent can be informed of who's
perfect.
been accessing the records. But someone thought earlier that every single employee of that school could have access to it, and that's not what we've ever
No,
held to be true.
it should be, and it doesn't have to even be the whole IEP. In Tennessee, specifically just portions of the IEP at a glance. Yeah, can be given for a bus driver if there's transportation issues. You know, if a student needs some sort of device on the bus or something like that, they will need access to that, or there are behavioral issues there. Yeah, just the IEP at a glance would be what you need, but only those employees that have an educational interest, or for the student's IEP. Good question.
District, if we're collecting ABC data, we collect it, we send it to our facilitator, and she types it up in a report for parents. But can parents request to see like our raw notes of ABC data? Can they see that?
I think they can.
It's only if it's kept in the due course of business as an educational record. If the notes are student specific, they'll probably be able to see that though, because that's involved in the student's evaluation and progress and stuff like that. But like a daily quiz, you're not having to keep all the daily quiz. You're not expected to keep every assignment.
If there are other questions, please feel free to ask now. Department of Ed is right here with us. And even though we're close, we can take 2 or 3 or 4 more minutes if you have a question.
It's only 8 letters, so it's easy to remember. Any other questions?
So just in talking and visiting with my wonderful colleague over here, she's an assistant principal with me, and we've just been talking, and there's frustration. Like IEP meetings are long, right? And we've tried as SPED director, I have tried to really streamline those. So what we're thinking about doing, other districts may already do this, I don't know. We were actually thinking about, could we move to, if everybody has a draft of the IEP, could we move toward a Google slide presentation that's more descriptive of the student, as long as it has the content of the IEP and everybody has a draft?
I don't see any problem with using visual aids, but as long as you're allowing the parents full input, like during all the slides, I think that'd be fine, and make sure that that record, that the slideshow is kept as a part of the student's educational record, and I think that would be
And I
fine,
hope
but-
it's painful to be in IEP meetings and have everybody read word for word.
Yeah.
And that really is the purpose of the draft going home. Now, there are going to be families who need to hear it, but it can be a summary, if you will, of that, as long as you're being descriptive enough that's informing the decisions of that team, and you're really hitting the critical components that are going to drive those decisions. But it shouldn't be reading the entire draft to a family, unless they need it, unless it's
if a parent requests or needs
right, or needs that,
English,
right. It could
English
be
second language
exactly
kind of
literacy, issues, any of that.
But yeah, like having those norms in place and setting the agenda, that sort of preparation is going to make things go a lot faster. We've been hearing the same things from districts about these meetings going so long and then having to reschedule 4 times to complete the meeting. And we know that can be such a burden, so we're trying to
And I think just establishing that up front, I know you've had an opportunity to review the draft, we certainly want to ask you any questions, but we're going to, kind of move through this and stop us at any point, just having that give and take.
I know the 48-hour rule wasn't very popular, but it does help the parents be prepared to come in with their questions so that hopefully they're not having to think of them in the moment. But yeah, you have a
I
question?
think just making sure too that you're not driving the decision, that it is still discussion based.
Yeah.
Yes, I think one of our main, me as an admin, having 10 or 15 of these a week that are at least an hour long each, when they're being read, everything, and you're 4% on closed vowel syllables, and the student is sitting there. So I don't know that it's, beneficial for that student to know. And the parents don't even know what a lot of that means. They just need to know that we're working on it. So that's why we're asking, can we just do an overview? And if they've been given that draft, that puts me out of my misery. And it also helps the parent just be aware of, hey, this is we've got the general idea. We've been doing this since the kid was in 4th grade or whatever. We just need to know what we're doing.
Make sure it's thorough and it's explaining everything to the parents.
But the key is they get that draft before the meeting.
Yeah, and if there's part of the draft that they want to go into detail, go into detail. Always, honor that suggestion. But yeah, just make sure you're hitting all the points that you need to hit and making sure those goals are being met. I think a visual aid would be helpful in a lot of circumstances.
That sounds
And I think that,
wonderful.
explaining why you've determined about the exceptionality, either it is or it is not. We've collected this data, and then that adverse impact statement, that's where that's really critical, because you've got all the jargon of your data and your, fluency words per minute and everything, but ultimately, how is this present level impacting, or this domain impacting their access? And this is what they're struggling with, and giving them that language. That's ultimately, I think, what the parents want to know. And then how are we going to help them, and how is that goal going to connect to that adverse impact?
All right. Thank you guys for your time. Appreciate it.
Thank you.
Mr. Tate Ball and Ms. Susan Ussery, thank you for being here.
We appreciate
A
it.
detailed presentation, and just thanks for taking Q&A. So,
Absolutely.
we appreciate it.
It's always good to be here.